Barrett of Indiana to be an Associate Justice of the Supreme Court of the United States, signed by 18 senators.
Pursuant to Rule 22, the Chair now directs the clerk to call the roll to ascertain the presence of a quorum.
Mr. Alexander, Ms. Baldwin, Mr. Barrasso, Mr. Bennett, Mrs. Blackburn, Mr. Blumenthal, Mr. Blunt, Mr. Booker, Mr. Bozeman, Mr. Braun, Mr. Brown, Mr. Burr, Ms. Cantwell, Mrs. Capito, Mr. Cardin, Mr. Carper, Mr. Casey, Mr. Cassidy, Ms. Collins, Mr. Coons, Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Kramer, Mr. Crapo, Mr. Cruz, Mr. Daines, Ms. Duckworth, Mr. Durbin, Mr. Enzi, Ms. Ernst, Mrs. Feinstein, Mrs. Fisher, Mr. Gardner, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Ms. Harris, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Ms. Hirono, Mr. Hoven, Mrs. Height-Smith, Mr. Inhofe, Mr. Johnson, Mr. Jones, Mr. Kane, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Lankford, Mr. Leahy, Mr. Lee, Mrs. Leffler, Mr. Manchin, Mr. Markey, Mr. McConnell, Ms. McSally, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Paul, Mr. Perdue, Mr. Peters.
Yeah, that's the tone.
Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Mr. Shelby, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young.
A quorum is present. The question is it the sense of the Senate that debate on the nomination of Amy Coney Barrett of Indiana to be an Associate Justice of the Supreme Court of the United States shall be brought to a close? The yeas and nays are mandatory under the rule. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. Mr. Barrasso. Aye. Mr. Bennett. Mrs. Blackburn. Aye. Mr. Blumenthal. Mr. Blunt. Aye. Mr. Booker. Mr. Bozeman. Aye. Mr. Braun. Aye. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Ms. Ernst. Mrs. Feinstein. Mrs. Fisher.
Aye.
Mr. Gardner. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Inhofe. Mr. Johnson. Mr. Jones. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Lankford. Mr. Leahy. Mr. Lee. Mrs. Leffler. Mr. Manchin. Mr. Markey. Mr. McConnell. Ms. McSally. Mr. Menendez. Mr. Merkley. Mr. Moran. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Paul. Mr. Perdue. Mr. Peters. Mr. Portman. Mr. Reed. Mr. Risch. Mr. Roberts. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Sass. Mr. Schatz. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Mr. Shelby. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Toomey. Mr. Udall. Mr. Van Hollen. Mr. Warner. Ms. Warren. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young. Senators voting in the affirmative: Alexander, Barrasso, Blackburn, Blunt, Bozeman, Braun, Burr, Capito, Cassidy, Cornyn, Cotton, Kramer, Crapo, Cruz, Daines, Enzi, Ernst, Fisher, Gardner, Graham, Grassley, Hawley, Hoeven, Hyde-Smith, Inhofe, Johnson, Kennedy, Lankford, Lee, Loeffler, McConnell, McSally, Moran, Paul, Perdue, Portman, Risch, Roberts, Romney, Rounds, Rubio, Sass, Scott of Florida, Scott of South Carolina, Shelby, Sullivan, Thune, Tillis, Toomey, Wicker, Young. Senators voting in the negative: Baldwin, Casey, Collins, Duckworth, Durbin, Heinrich, Hirono, Jones, King, Klobuchar, Leahy, Manchin, Murkowski, Murphy, Murray, Peters, Reed, Sanders, Schatz, Smith, Udall, Wyden. Ms. Warren, no. Mr. Schumer, no. Mr. Tester, no. Mr. Coons, no.
From a previous.
Ms. Cantwell, no. Mr. Blumenthal, no. Mr. Markey, no. Mr. Cardin, no. Ms. Stabenow, no. Mr. Kane, no. Ms. Hassan, no. Mr. Whitehouse, no. Ms. Rosen, no. Mr. Van Hollen, no. Ms. Sinema, no. Mr. Menendez. Mr. Menendez.
He's going to go home after.
No. Mr. Booker. Mr. Booker. No.
Here between 8 and 10, and then I'll come back anytime between.
Ms. Cortez Masto. No. Mr. Warner. Mr. Warner. No. Mr. Brown. Mr. Brown. No. Mrs. Feinstein. Mrs. Feinstein. No. Mr. Carper. Mr. Carper. No. Mr. Bennett. Mr. Bennett. No. Mr. Markley. Mr. Markley. No. Mrs. Gillibrand. Mrs. Gillibrand. No. Mrs. Shaheen. Mrs. Shaheen, no.
On this vote, the yeas are 51, the nays are 48. The motion is agreed to.
Madam President,
The Majority Leader.
we have order in the Senate.
The Senate will be in order. The Majority Leader.
So, Madam President, let me begin this afternoon with the following quote. Few men in society will have sufficient skill in the laws to qualify them for stations of judges. And the number must be still smaller of those who unite the requisite integrity with the requisite knowledge. That was Alexander Hamilton in Federalist 78. Now, the framers knew the independent judiciary would be a crucial part of this new experiment in self-government. If the separation of powers was to endure and the people's rights were to be safe, we would need individuals of the highest quality on the courts. So how fortunate for our country that the Senate just advanced one of the most qualified nominees for judicial service that we've seen in our lifetimes. Judge Amy Coney Barrett of the U.S. Court of Appeals for the Seventh Circuit is a stellar nominee in every single respect. Her intellectual brilliance is unquestioned. Her command of the law is remarkable. Her integrity is above reproach. First, as an award-winning academic and then as a circuit judge, she's worked her way up to the pinnacle of the law. But just as importantly, Judge Barrett has displayed zero willingness to impose personal views or clumsily craft new policy with her gavel. She's demonstrated the judicial humility, the neutrality, and the commitment to our written Constitution that are essential for this office. By now, Madam President, as tends to happen by the end of these processes, the Senate knows Judge Barrett very well. Senators saw the Judiciary Committee put the nominee through her paces with days of exhaustive questioning. We've been able to study nearly 100 opinions she's issued in 3 years on the federal bench. We've had another opportunity to examine the 15 years of scholarly writings that most of us reviewed 3 years ago when Judge Barrett won bipartisan confirmation to her current job. And we've been deluged by personal testimonies from every corner of Judge Barrett's career and life to confirm just what a remarkable person this nominee is. One of Judge Barrett's former colleagues at Notre Dame is a leading expert in comparative constitutional law. That means he studies the courts and constitutions of countries all around the world. He meets judges from across the planet. Here's what this expert says about his colleague. I have had very many occasions to meet, observe, and work with high court judges from all over the world, from Argentina to Austria, from South Africa to South Korea. And I can say with great certainty that Judge Barrett stands out on a par in her abilities with the most distinguished of them all. He goes on to say her legal work is erudite as it is clear and accessible, and as honest and fair-minded as anyone could aspire to, with not a hint of personal bias. Now, most of us would be thrilled to receive such praise once or twice in an entire career. But Judge Barrett seems to provoke this reaction in absolutely everyone. The highest professional compliments seem to be the default reaction of anybody who crosses her path, anybody who comes in contact with her. 81 of her law school classmates from diverse backgrounds, political affiliations, and philosophies say the nominee embodies the highest caliber of intellect, fair-mindedness, empathy, integrity, humility, good humor, and commitment to justice. They also said, as fellow students, we've learned more from Amy than the professor. Learned more from Amy than the professor. 3 years ago, more than 70 fellow scholars wrote the Senate calling her scholarship careful, rigorous, and fair-minded. They said her personal integrity earns wide respect. And listen to this, every one of the Supreme Court alumni who clerked alongside Judge Barrett wrote us to share their unanimous view that she is a woman of remarkable intellect and character. That means, colleagues, that was the clerks to Ginsburg and the clerks to Breyer as well, all of them, without exception. Now, how did that clerkship come about? By the way, after one of her professors, who's now a university president, wrote Justice Scalia with one sentence, Amy Coney Barrett is the best student I ever had. But before she clerked for the Supreme Court, she clerked for Lawrence Silberman on the D.C. Circuit, who by his own admission is an Ivy League snob. And he got a call one day from a professor at Notre Dame, and he said, you know, I know you only take clerks from mostly Harvard and Yale, but this is the best student I ever had at Notre Dame. And so this Ivy League snob decided to take a chance on somebody who didn't go to Harvard or Yale. That was Amy Coney Barrett, and then he called his good friend Nino Scalia, and he said, goodness gracious, you don't want to miss this opportunity to have this clerk. So we've got here a uniquely qualified person. And the best evidence of it is you don't hear anything over there about her qualifications. Not a peep about her talent, her intellect. We've got colleagues the perfect nominee for the Supreme Court. A few weeks ago, Harvard law professor Noah Feldman, who leans left, wrote that Judge Barrett is a brilliant and conscientious lawyer who will analyze and decide cases in good faith. He said she meets and exceeds the basic criteria for being a good justice. So, as I was saying, no matter all the acrimony that swirled around the process, nobody's attempted to dispute Judge Barrett's qualifications. To the contrary, no one can help being impressed. At one point during Judge Barrett's hearing, she was asked about an arcane legal doctrine. Her answer was so clear and so accessible that one of our Democratic colleagues, I won't name him, I don't want to get him in trouble, had to remark, quote, "That's quite a definition. I'm really impressed." Well, so are the American people. Some opportunities, some opponents of this nomination come right out and say, quote, "It's not about qualifications." They deserve some credit for being honest about it. They say they aren't interested in whether Judge Barrett will smartly and faithfully apply our laws and our Constitution. They aren't interested in that. Instead, they want to make apocalyptic predictions about policy. Well, there are a few problems with that. One is that their political side has been shopping the same horror stories for 50 years. They've been saying the same thing for a half a century about every Supreme Court nominee by a Republican president, without exception. And many of those judges, not to the delight of some people on this side of the aisle, went on to not disappoint the other side, which shows you how hazardous it is to predict what someone will be for a lifetime. Many have been surprised, some unpleasantly. It's almost as if jurists are not politicians with policy platforms. It's almost as though that's the wrong way to look at it. That is a deeper misunderstanding of what's at play here. Let me quote an expert. "A judge must apply the law as written, not as she wishes it were." Scalia used to put it this way. He said, "If you want to make policy, why don't you run for office?" That's not what we do here. That's not our job. It takes a good deal of discipline to squeeze your personal opinions out of your decision making. That's the kind of judges we've been confirming here for the last 4 years. People who are sworn to uphold the law and take it seriously. President Obama once said he wanted to appoint judges who had empathy. Think about it for a minute. If you're the litigant for whom the judge has empathy, you're probably in pretty good shape. But what if you aren't? That's not what we've been doing here for the last 4 years with the judiciary. And the reason that frightens these guys on the other side so much is because that's exactly what they want. Another branch of legislators seeking outcomes that may or may not be reflected in the law or the Constitution that's before them. It's exactly what they want. Courts have a vital responsibility to enforce the rule of law, which is critical to a free society, but the policy decisions and value judgments of the government must be made by the political branches elected by and accountable to the people. The public should not expect courts to do so, and courts shouldn't try. Now, who said that? That was Amy Barrett who said that. She understands the separation of powers far more keenly than her critics. She understands the job of a judge. Our Democratic colleagues should not have tried to filibuster this exceptional nominee. They should have listened and actually learned. I loved during the hearing when Senator Cornyn said, "What do you have on your notepad?" She held it up, nothing. Nothing. no notes at all. And we got 2 former Supreme Court clerks on that committee, Senator Cruz, Senator Hawley. And I've heard them say over and over again, oh, 3? Oh, Mike, sorry. 3. So they've been around the best at the highest level. Nobody's seen anything better than this. This is something to really be proud of and to feel good about. We made an important contribution to the future of this country. A lot of what we've done over the last 4 years will be undone sooner or later by the next election. They won't be able to do much about this for a long time to come. Fortunately for Judge Barrett and for our nation, history will remember what is already clear. The deficiency is with their judgment, not hers. Their judgment, not hers. The Senate is doing the right thing. We're moving this nomination forward, and colleagues, by tomorrow night, we'll have a new member of the United States Supreme Court.
Madam President.
The Senate will be in order. The Senate will be in order. The Democratic leader.
Thank you, Madam President. Now, I want to start today by talking about some breaking news that may at first glance not seem relevant to today's proceedings, but in fact is a perfect illustration of how broken this process is. We find ourselves in the middle of a pandemic that the Republican Party has never taken seriously enough. Can we have order, Madam President?
The Senate will be in order. Please take your conversations out of the chamber.
As I said, the Republican Party has never taken this pandemic seriously enough, and it's a pandemic that's worsening by the day. According to Dr. Fauci, the nomination ceremony for Judge Barrett was a super spreader event. Today, the White House Chief of Staff conceded the White House is, quote, not going to control the pandemic. And yet, last night we learned that several aides close to Vice President Pence have tested recently positive for COVID. Now, we wish them and their families well. We wish the Vice President and his family continued health. But a normal response after being close to several people with COVID-19 would be to follow CDC guidelines and quarantine for everyone's safety. But this is not the case. In the same breath with which they announced that Vice President Pence was exposed, the White House said that he would keep on campaigning, comparing campaigning work to the work that doctors and nurses and firefighters and police officers do. It's a puzzling claim, especially since the Vice President failed at the most important official duty in his portfolio, the White House Coronavirus Task Force. Not only has the White House Coronavirus Task Force failed to keep the American people safe, it has even failed to keep the White House safe. Even worse, the Vice President reportedly intends to come to this chamber tomorrow to preside over Judge Barrett's confirmation vote. The Vice President, who's been exposed to 5 people with COVID-19, will ignore CDC guidelines to be here tomorrow, putting the health of everyone who works in this building at risk. It sets a terrible, terrible example for the American people. And nothing could be a more apt metaphor for what's going on here. The Republican Party is willing to ignore the pandemic to rush this Supreme Court nomination forward. And the Vice President, after being potentially exposed to COVID, will preside. Senate Republicans are willing to ignore the need for economic relief. They're willing to ignore the nation's testing needs. They're willing to ignore election interference, all so they can put someone on the highest court who would take health care away from millions of Americans in the middle of a pandemic. God save us. Now, only a few hours after Justice Ruth Bader Ginsburg passed away, Leader McConnell announced the Republican majority would move quickly to confirm her replacement. At the time, we didn't know exactly when, but now we do. Republicans are rushing to hold a confirmation vote tomorrow night, 8 days before the election. And after more than 50 million Americans have voted for president, quite possibly a different president, to pick justices on their behalf. After more than 50 million Americans have voted for senators, quite possibly different senators than some who are here today, to advise and consent. Confirming a lifetime appointment this late into a presidential election season is outrageous. It is even more galling, of course, because nearly every Republican in this chamber, led by the majority leader, 4 years ago refused to even consider the Supreme Court nomination of a Democratic president on the grounds, the principle that we should wait until after the presidential election because the American people deserved a voice in the selection of their next justice. My colleagues, there is no escaping this glaring hypocrisy. As I said before, no tit-for-tat, convoluted, distorted version of history will wipe away the stain that will exist forever with this Republican majority and with this Republican leader. No escaping the hypocrisy, but oh my, how the Republican leader has almost desperately tried. Over the past few days and weeks, the majority leader has subjected the Senate to a long and tortured defense of this cynical power grab. Madam President, can we please have some order? Thank you.
The Senate will be in order. Please take your conversations out of the chamber.
A long and tortured defense of this cynical power grab. The Republican leader claims the majority's position all along has been that it's acceptable to deny justices in presidential election years when there's divided government. But here's what Leader McConnell said after Justice Scalia died. The American people should have a voice in the selection of their next Supreme Court justice. Therefore, this vacancy should not be filled until we have a new president. He didn't say the American people should have a voice, but only when there's divided government. He didn't say the American people deserve a voice, but only when it serves the political interests of one party. Otherwise, we don't mean it. No, Republicans all swore this was a principle, their word, not mere incident of who controls the Senate and the presidency. And the transparency of this new excuse does not cover up the hypocrisy, does not change it one bit, and everyone knows it, everyone. And by the way, if this were about divided government, The senior senator from Florida would not have said he would, quote, say the same thing if a Republican president were in office. The junior senator from Iowa would not have said, precedent set, precedent set. I'm sure come 2020 you'll remind me of that. Chairman Graham would not have said, hold the tape. Use my words against me. You can say Lindsey Graham said the next president, whoever it might be, not whatever party it was in, should make the nomination. So the flimsiness, the transparency, the dishonesty of the excuse that they've come up with ex post facto doesn't work. So, no, this has never been about the orientation of the Senate and the presidency. Republicans promised they'd follow their own standard if the situation was reversed. Guess not. Now, the Republican leader claims that the majority's actions today are rooted in some convoluted precedent. The truth is, the precedent is clear and simple. The Senate has never confirmed a Supreme Court justice so close to a presidential election. The Senate has never even confirmed a justice between July and Election Day in a presidential year. I asked the presiding officer to confirm these two facts, and both were confirmed by the records of the Senate. There is no precedent, none, for what is going on here. And the Republican leader has claimed that the majority's actions are justified by all sorts of bad things Democrats did in the past and may hypothetically do in the future. He said that every escalation of significance in judicial debates was made by Democrats. Convenient, I guess. I guess significance is in the eyes of the beholder because the Republican leader's history, conveniently and mandatorily to make his case, his false case, left out a whole lot of chapters, ignored. He conveniently admitted that Republicans bottled up more than 60 judicial nominees from President Clinton, refusing to give them a hearing in the 1990s. He made no reference to the decision by Republican senators to hold open 14 appellate court seats under President Clinton so a Republican president could fill them instead, a tactic Republicans would revisit under President Obama when Republicans used partisan filibusters to block his nominees to the D.C. Circuit. At the time, the Republican leader and senators from Iowa and Utah said that President Obama was, get this, trying to pack the court. Amazing. Pack the court? They held up the nominations so President Obama couldn't have his rightful appointees to the second highest court in the land, and they kept a number of seats, I believe it was 4, vacant for such a long time. Well, we've heard all this before. It seems whenever the Republicans need to scare up some votes, they accuse Democrats of trying to pack the courts, even when it's a Democratic president invoking his constitutional authority to appoint judges and the Republicans blocking it. Now, Republicans tried to nullify President Obama's authority to nominate judges to the Circuit Court. And then, as soon as Republicans had a majority, they succeeded in nullifying his prerogative to have a Supreme Court nomination considered by the Senate. And what did Leader McConnell say about it? This remark will go down in infamy. He called it one of his proudest moments. Apparently, the blame game Leader McConnell wants us to play goes all the way back to 1987. That's the reason we're so hypocritical. What happened back in 1987, says the Republican leader. It all began with Robert Bork, he says, after Senator Kennedy gave a 3-minute speech that Republicans considered intemperate. Seriously, that is, according to our Republican friends, the original sin, according to the leader, a 3-minute speech. While we're on the subject of Robert Bork, I'd remind my colleagues that Robert Bork received a hearing and a vote in the Democratic Senate. His nomination was defeated by a bipartisan majority of Republicans and Democrats. Republicans helped defeat Bork, left out conveniently by the leader's recantation of history. His nomination was defeated, and President Reagan's eventual replacement, Anthony Kennedy, was confirmed unanimously. For those keeping score, Merrick Garland never even got a hearing. But because one Democrat gave a speech Republicans didn't like, the fight was on, according to the Republican leader. According to the Republican leader, because of that 3-minute speech in 1987, Republicans can steamroll the minority to confirm a Supreme Court justice in the middle of an election. Imagine trying to explain to someone, sorry, I have to burn down your house because of something one of your friends said about one of my friends 33 years ago. Yep, burn down the house because of a comment 33 years ago. That's what they're doing. Mr. President, the leader's speech, the Republican leader's speech, was schoolyard stuff. Here in the United States Senate, in order to justify an outrageous power grab that even some members of his party don't agree with, the leader's argument boils down to, but you started it. Any parent with young children would recognize that argument. It's when you know you've done something wrong, but you don't want the blame. That's exactly what the leader's speech sounded like to so many Americans. Let's get serious here. This isn't about the long history of judicial escalation or a 33-year-old speech. This is about raw political power. This is about a Senate majority deciding to break faith with the American people and make a mockery of its own principle to secure a seat on the Supreme Court. And let me dispense with one more fiction. The leader keeps claiming that Supreme Court seats have nothing to do with power or ideology. Judges and justices only apply the law, they claim. They only call balls and strikes. My Republican friends have told us over and over again that if someone is qualified, has good top-notch qualifications, they should be confirmed because judges merely apply the law. Well, if that were true, if Leader McConnell truly believed the only thing that matters about a judicial candidate is his qualifications, then Merrick Garland would be sitting on the court right now. His qualifications were every bit as good as Amy Coney Barrett's. Every bit as good. So all of a sudden, we should only judge by qualifications. I get it. I get it. So if it were true, once again, I will repeat it. If any of my Republican friends believe that the only thing that matters is the qualifications of a judicial candidate, Merrick Garland would be Justice Merrick Garland now. No one said Judge Garland wasn't qualified, but Republicans subjected his nomination to an unprecedented partisan blockade. If qualifications are the only thing that matters, why did President Trump vow to pick only justices who would terminate our health care law? Why did he say that his judicial appointments would, quote, do the right thing on health care, unlike Justice Roberts? Why did President Trump say if he gets to appoint 2 or 3 justices to the Supreme Court, Roe v. Wade would be overturned automatically? That's not qualifications. President Trump doesn't have a problem talking about how judicial appointments might rule when he's trying to win an election. But apparently Democrats are, quote, in the words of the leader, hysterical for even questioning how Judge Barrett looks at hugely consequential issues. I want the American people to know the far right is lining up right now to get the Supreme Court to review your fundamental rights because they think Judge Barrett might provide a certain outcome. President Trump and Republican attorneys general are suing to eliminate the Affordable Care Act in a case that will be heard 1 week after the election. 3 days ago, the President of the United States said on tape, quote, I hope that they will end it. It'll be so good if they did. Republicans in Pennsylvania have just appealed a split decision by the current Supreme Court that prevented an early cutoff to counting ballots. Just one vote on the court could change that outcome. The Attorney General of Mississippi this week filed a brief asking the Supreme Court to review a Mississippi law banning abortions after 15 weeks, an invitation for a new configuration on the court to revisit Roe v. Wade. So don't tell me the issues don't matter, only qualifications. We're talking about the lives and freedoms of the American people, the right to affordable health care, to make their own private medical decisions, to join a union, vote without impediments, marry who they love. And Judge Amy Coney Barrett will play a part in deciding whether those rights will be sustained or curtailed for the next generation of Americans. So I want to be very clear with the American people about what's going on here. The Republican Senate majority, America, is breaking faith with you, doing the exact opposite of what it promised just 4 years ago, to cement a majority on the Supreme Court that threatens your fundamental rights. Don't forget it, America. Don't forget what's happening here, because it's a travesty, a travesty, a travesty for the Senate, a travesty for the country, and it will be an inerasable stain on this Republican majority forevermore. I yield the floor.
Well done.
Madam President.
The Majority Whip.
Madam President, the Democratic leader seems to think that this had something to do with a 3-minute speech 30 years ago. I don't know where that comes from. I can tell you that he has been involved in a systematic reversal of the long-standing precedent when it comes to the consideration of judges to the federal bench by the United States Senate. And I'm a beneficiary, I suppose you could say, in some strange way of that. That was a major issue in my campaign in 2004. We made it about the blockade that the Democrats in the Senate at the time, led by the current Democratic leader, had started against a whole long list of nominees put forward by then President George W. Bush. Well, I'll remind you of a few names: Janice Rogers Brown, Priscilla Owen, Miguel Estrada, Judge Charles Pickering. There was a long list of judges that were blocked at the time by the current Democratic leader. In fact, as the Leader McConnell has pointed out, it wasn't even sort of a random thing. It was a planned strategy to start playing politics with the federal judiciary, instigated by the architect, the current Democratic leader, who at the time was holding workshops and seminars about how they could politicize the federal judiciary and figure out new ways to block consideration of judges put forward to the federal bench by then President George W. Bush. So that was a major issue in that campaign season, and I would argue one of the principal reasons that I am here in the United States Senate. So it's and then of course when the chickens came home to roost and the same tactics were used by the other side in a previous administration, as was pointed out again yesterday by Leader McConnell, the Democrats decided to break the rules, to change the rules in 2013 to go to a simple majority to basically get and confirm judges on the federal judiciary. So we are where we are today, notwithstanding all the bluster that you just heard, because of a long, systematic strategy by the Democratic leader to block judges put forward by Republican presidents. But, Mr. President, despite all of what you just heard, tomorrow we are going to get to vote to confirm one of the most outstanding judicial nominees that I've had the pleasure of considering during my time in the Senate. Judge Amy Coney Barrett is eminently qualified for the Supreme Court. By now, her accomplishments are well known. First in her class at Notre Dame Law School, Supreme Court clerk, beloved Notre Dame law professor, outstanding scholar, circuit court judge. Americans, of course, got to see Judge Barrett's qualifications for themselves a couple of weeks ago during her Judiciary Committee hearing. For 2 days, she answered tough and probing questions from Democrats and Republicans, displaying a consummate command of the law and a calm and thoughtfulness that shows she has the kind of judicial temperament you want in a Supreme Court justice. Mr. President, since Judge Barrett's nomination, the tributes have poured in from across the political spectrum. I quote, "Barrett is highly qualified to serve on the Supreme Court," said Harvard law professor Noah Feldman, one of the House Democrat star impeachment witnesses. Patricia O'Hare, former dean of Notre Dame Law School, sent a glowing letter to Judiciary Committee Chairman Lindsey Graham and Ranking Member Dianne Feinstein. And the letter, and I quote, goes, "I was the dean of Notre Dame Law School at the time that Judge Barrett first joined our faculty. In that capacity, I was responsible providing an environment in which she could flourish as a young faculty member, but also for evaluating objectively whether she met the university's high standards for scholarship and teaching required for advancement. This proved to be the easiest task of my 10 years as a dean. Judge Barrett was and remains a stellar teacher, beloved by students, a brilliant and nationally recognized scholar, and a generous colleague. I am confident," she went on to say, "that if she is confirmed by the United States Senate, she will be an outstanding justice, brilliant, fair, impartial, and empathetic, and will serve to strengthen an independent judiciary committed to the rule of law." End quote. And Mr. President, Professor O'Hara also took care to note in her letter that she doesn't write glowing reviews for federal judiciary nominees on a regular basis. In fact, she said the only similar letter she has ever written was in support of Democrat nominee Elena Kagan's nomination to the Supreme Court. She went on, and I quote, "I feel every bit as strongly about Judge Barrett's qualifications for a position as Associate Justice as I felt about Justice Kagan. And while I've not always agreed with the American Bar Association's judicial rankings, they certainly got it right with Judge Barrett." And that's me talking, not the professor. Mr. President, I'm still struck by the testimony that the head of the ABA Standing Committee on the Federal Judiciary submitted to the Senate Judiciary Committee. The ABA Standing Committee on the Federal Judiciary is the body that provides the ABA's evaluations of federal judicial nominees. In his testimony detailing the well-qualified rating that the ABA gave to Judge Barrett, the head of the ABA committee noted, and I quote, "Lawyers and judges uniformly praised by the nominee's integrity. Most remarkably, in interviews with individuals in the legal profession and community who know Judge Barrett, whether for a few years or for decades, not one person uttered a negative word about her character. Accordingly, the Standing Committee was not required to consider any negative criticisms of Judge Barrett." End quote. Mr. President, that's quite a tribute. But of course, ratings of well-qualified do not just depend on character. They also depend on professional competence. And here's what the ABA's representative had to say about that. And again, I quote, "Given the breadth, diversity, and strength of the positive feedback we receive from judges and lawyers of all political persuasions, and from so many parts of the profession, the Standing Committee would have been hard-pressed to come to any conclusion other than that Judge Barrett has demonstrated professional competence that is exceptional." End quote. And Mr. President, along with her character, competence, and command of the law, Judge Barrett brings a clear understanding of the proper role of a judge. She understands that the job of a judge is to interpret the law, not make the law, to call balls and strikes, not to rewrite the rules of the game. Or as Judge Barrett said in answer to a senator's question, "I apply the law, I follow the law, you make the policy." As Judge Barrett made clear in her hearing, she will be the kind of justice who leaves her personal beliefs and political opinions at the courtroom door. She will look at the facts of each case and judge according to the law and the Constitution and nothing else. Mr. President, when I came to the Senate, I hoped to have the opportunity to put judges like Amy Coney Barrett on the bench. I was proud to vote to confirm her to the Seventh Circuit Court of Appeals in 2017, and I look forward to voting to confirm her to the Supreme Court tomorrow. Mr. President, I yield the floor.
President.
Senator from California.
Mr. President, I rise today in opposition to the nomination of Judge Amy Coney Barrett to the United States Supreme Court. Just over a month ago, our country lost Justice Ruth Bader Ginsburg, a leading voice for equality and fundamental rights. Judge Ginsburg's nomination was the first that I participated in when I came to the Senate 28 years ago. At her hearing, I had the opportunity to thank her for all she had done and for all she had yet to do. Before she was confirmed to the bench, Justice Ginsburg played a critical role in breaking down barriers for women. During her confirmation hearing, she staunchly and forthrightly defended her positions as an advocate for equality, including her own support for a woman's fundamental right to control her own body, the core holding of Roe v. Wade. Excuse me. Once confirmed to the court, Justice Ginsburg worked tirelessly to ensure that the opening words of our Constitution, "We, the people of the United States," included all people, not just the elite few. So the stakes are extraordinarily high in confirming a replacement for Justice Ginsburg in the best of circumstances. But for Republicans to proceed now, just 8 days before an election, undermines, I think, the integrity and independence of the vote. Senate Republicans are breaking their own statements and promises by proceeding. In February of 2016, Republicans refused to consider a replacement for Justice Antonin Scalia because it was an election year. They blocked all consideration of President Obama's nominee, Judge Merrick Garland, claiming that the American people should have the opportunity to weigh in on a Supreme Court vacancy. Leader McConnell, at the time, clearly stated the Republicans' position, quote, "My view, and I can now confidently say the view shared by virtually everyone in my conference, is that the nomination should be made by the president that the people elect in the election that is now underway," end quote. Well, that's clearly not going to happen. Chairman Graham, in 2018, reiterated this standard, promising that if, quote, "an opening comes up in the last year of President Trump's term and the primary process is started, we'll wait till the next election," end quote. But when Justice Ginsburg passed away just 46 days before Election Day, Senate Republicans did not hesitate to go back on their word. On the night of Justice Ginsburg's death, Leader McConnell announced that President Trump's nominee for the vacancy would receive a vote on the Senate floor. And Chairman Graham immediately set committee hearings for October 12, giving the committee just 2 weeks to review Judge Amy Barrett's record. This proved to be insufficient, as evidenced by Judge Barrett's failure to identify and disclose significant amounts of material. Then, before Judge Barrett's hearing had even concluded, Chairman Graham held a markup on her nomination, and more rules were broken by setting a committee vote on her nomination for 1 p.m. the following week. I, along with the Democratic side, refused to take part in that committee vote. But this was not a decision that we made lightly. We were not willing to participate in any further in a process that was used to rush this nominee forward in the middle of this election. Despite our objections to proceeding, Democrats demonstrated through the course of Judge Barrett's nomination hearing what's at stake with her nomination. starting with Republican statements to use the Supreme Court to dismantle the Affordable Care Act and strip away health care coverage for millions of Americans. On November 10th, the Supreme Court will actually hear oral arguments in a case titled California v. Texas. That's a case challenging the validity of the Affordable Care Act. President Trump promised to appoint justices who will vote to dismantle this landmark law. In 2015, he stated, quote, "If I win the presidency, my judicial appointments will do the right thing, unlike Bush's appointee, John Roberts, on Obamacare," end quote. When he nominated Judge Barrett to fill Justice Ginsburg's seat, President Trump stated that eliminating the ACA would be a, quote, "big win in the USA," end quote. And even more recently, in an interview with 60 Minutes, President Trump said he, quote, "hopes the Supreme Court will strike down the ACA, and he believes, quote, it'll be so good if they end it," end quote. Let us not forget, after all, that Justice Ginsburg joined a 5-4 majority when the Supreme Court upheld the ACA against Republican-led challenges in NFIB v. Sebelius and King v. Burwell. Like President Trump, Judge Barrett has criticized the upholding of the Affordable Care Act in FFIB v. Sebelius. She stated that Chief Justice Roberts, quote, "pushed the Affordable Care Act beyond its plausible meaning to save the statute." She also cast doubt on the Chief Justice's opinion in King v. Burwell and said that he departed from, quote, "the clear text," end quote, "of the statute to end gutting it." She likewise claimed that the dissent had, quote, "the better of the legal argument," end quote. At her confirmation hearing, Judge Barrett did not answer questions about her view on the ACA and did not meaningfully walk back her criticism of these two 5-4 Supreme Court decisions upholding the law. She also implied that coverage of pre-existing conditions is not an issue in California v. Texas. However, the Trump administration is directly asking the court to strike down the entire Affordable Care Act, including its protections for patients with pre-existing conditions. Let me be perfectly clear. I believe if Judge Barrett is confirmed, Americans could well lose the significant benefits that the Affordable Care Act provides. More than 130 million Americans, Mr. President, have pre-existing conditions like cancer, asthma, or even COVID-19, and they could then be denied coverage. At Judge Barrett's hearing, we heard the stories of real Americans who will be harmed and who illustrate what's at stake. This included a constituent of mine, Christina Monroe Garcia, who, because of the Affordable Care Act, received cataract surgery that saved her eyesight. It included North Carolina mom Stacey Staggs, who testified that the Affordable Care Act had ensured her twin girls receive life-saving treatments they needed. And it included Dr. Farhan Bhatti, a family physician working with low-income patients in Lansing, Michigan, who told the committee that opposition to the ACA, quote, endangers a lifeline that his patients count on to stay healthy and in many cases to stay alive, end quote. I deeply believe that Senate Republicans should not be moving forward on a justice who will likely help strip health care from millions of Americans, particularly in the middle of a global pandemic that has already taken more than 225,000 American lives. Judge Barrett also represents a threat to women's reproductive rights. President Trump has told us so when he promised to appoint justices who will, quote, automatically, end quote, overturn Roe v. Wade. And Judge Barrett has made clear that she would likely be the court's most extreme member on reproductive rights. At her hearing, she refused to state whether she agreed with the landmark case Griswold v. Connecticut, which established the right to use contraceptives. In addition, she would not affirm whether Planned Parenthood v. Casey, which upheld the constitutional right to abortion established in Roe, was settled law. And she stated outright that Roe is not a super precedent, indicating time and again that continued efforts by anti-abortion activists would provide the Supreme Court ample future opportunity to further limit or overturn Roe entirely. Now, this was a surprising departure from the last four Republican nominees, who acknowledged at their hearings that Griswold is, in fact, settled law, and that Roe and Casey are, in fact, important precedents of the court. Beyond these specific examples, Judge Barrett's view of precedent itself poses a continued threat to countless rights that Americans rely on and cherish. As an academic, she wrote that it is, quote, more legitimate, end quote, for a justice to, quote, enforce her best understanding of the Constitution rather than a precedent she thinks clearly in conflict with it, end quote. Essentially, what that states is that she will feel free to overrule precedent that she believes conflicts with her interpretation of the Constitution. Judge Barrett's record also raises grave concern about how she would rule on cases involving voting rights and core democratic norms. In her dissent in the Seventh Circuit case, Cantor v. Barr, Judge Barrett suggested that voting rights are entitled to less protection under the Constitution than the right to own a gun. She distinguished between, quote, the individual right to own a gun and the civic right to vote. She argued that a felony conviction should not necessarily result in the loss of the right to own a gun, but emphasized that it may result in the loss of the right to vote. She even refused to say whether discrimination exists, even after being informed that Chief Justice Roberts wrote, and I quote, "Voting discrimination still exists. No one doubts that," end of quote. And despite President Trump's statement that he plans to challenge the results of the election in the courts if he loses, and that he wants his justice seated in time to hear those challenges, Judge Barrett would not commit to recuse from cases relating to the upcoming election. In addition, Judge Barrett's evasiveness at her hearing was deeply concerning. She refused to answer over 100 questions, not 10 or 20 or 30 or 40, but 100 questions, including basic legal and factual questions. Let me give you an example. Judge Barrett refused to confirm that the Constitution prevents a president from delaying an election. That's a hint. She declined to answer whether federal law prohibits voter intimidation. She would not affirm that Medicare is constitutional. She even hedged on whether presidents should commit to a peaceful transfer of power. And she would not acknowledge the existence of climate change. Judge Barrett's silence on these major questions really speak volumes. It demonstrates that a Justice Barrett will not be willing to stand up for core American values and rights, and raises additional concerns about her willingness to act independent of President Trump. In closing, it is my belief that Judge Barrett represents a threat to the very rights, including reproductive rights, rights of LGBT individuals, and voting rights that Justice Ginsburg worked so hard to protect. And for those reasons, I oppose her nomination and urge my colleagues to do the same. Thank you very much, Mr. Chairman. President, I note the absence of a quorum.
The clerk will call the roll.
Mr. Alexander.
Senator from Illinois,
As consent, the quorum call be suspended.
without objection.
Mr. President, if you went across America, thank you. Mr. President, if you went across America and just picked a random person and said, did you know the Senate's in session this weekend? They, of course, wouldn't know. And you'd say to them, well, why do you think the Senate is in this rare 5-day session? And they would say, I'm sure. Well, of course they're in a rare 5-day session. We're in the midst of a deadly pandemic. And you would guess that would be the answer of most Americans. Why would they say that? Well, I know why they'd say it in Illinois. Because coronavirus in Illinois has spiked to a newly confirmed daily COVID-19 state record as of yesterday. And 63 more deaths have been reported. Our positivity rate is over 6% now. And the governor and mayor are taking steps they didn't want to take but have no choice. They're closing restaurants and bars, imposing a curfew on the city of Chicago. You can imagine how they feel as more and more infections come rolling in and more people are dying. We have almost 9,600 deaths so far in Illinois, and as we know, nationwide over 222,000 deaths. But don't believe for a second that this is a big city problem, because the New York Times reports this morning in its edition the names of the 50 counties across America with the worst per capita outbreaks of COVID virus, with fewer than 10,000 people in the county. Senator Thune was here earlier. His state of South Dakota has really been devastated when it comes to small counties. These counties, Bon Homme, Falk, Harding, Minor, Buffalo, Ogallala, Lakota, Sully, Campbell, Brule, Turner, Jackson, Todd. Small counties, rural areas. Small town America that used to say it's a big city problem, but now sadly it's a small town problem too. I'm sure the presiding officer knows that on this list of 50 is Izard County, if I hope I pronounced that correctly, in Arkansas, and Lincoln County as well. Following me speaking will be a senator from Colorado, and unfortunately Sedgwick County is included on this list. The point I'm trying to make is this. This is a pandemic that is the worst we've seen in a century. More people are getting sick and more people are dying than we ever imagined. We face this not just in big cities like Chicago, but in small towns and small counties in my state of Illinois and everywhere. I pointed out the senators who've been recently on the floor, but trust me, this list includes a lot of other states, even with Democratic senators. It makes no difference. The virus could care less. With facing this at this moment in time, the American people would rightly think that we would be doing everything imaginable, everything within our power to address this pandemic in this rare 5-day session leading up to a national election. But they would be wrong. They would be wrong because that is not our priority in the Senate. Our priority is the filling of a vacancy on the Supreme Court. And the nominee, Amy Coney Barrett, comes before us for a vote of confirmation tomorrow after 5 days. The reason it's controversial, the reason it has to be rushed from the Republican point of view, the reason why they are hell-bent to get this done before the election is directly related to the pandemic. Seems like an odd coupling. How did that happen? Well, it came down to this. The filling of this vacancy in an extraordinary way, since we have never, underline the word never, in the history of the United States, filled a Supreme Court nomination vacancy this close to an election, actually in the midst of an election. It's never been done. The reason why they're breaking all the rules, including the sacred McConnell rule, which was announced 4 years ago, that lame duck presidents, by his definition, presidents in their last year, should have no authority to fill a Supreme Court vacancy. The reason why they've decided to ignore that sacred McConnell rule and to go forward with this is because of one day that is coming up, November 10th. You see, on November 10th, the Supreme Court of the United States considers the case of Texas versus California. It's a big deal on the Republican side. The purpose of that case is for attorneys general in Republican states and the Attorney General of the United States to strike down the Affordable Care Act. They want to make sure that Amy Coney Barrett has black robes on and is sitting in the Supreme Court when it is argued, so she can be there when the critical vote to eliminate the Affordable Care Act occurs just a few weeks from now. And if they don't get this done by November 3rd, they're afraid of what might happen. Something might get complicated. They couldn't get her on the bench in time. And if you think I'm making this up, we have as a source for that information none other than the President of the United States of America. A president who never suffered an unuttered thought. A president who generates dozens of tweets every day, tells us exactly what's on his mind every waking moment. And he made it clear to us that when it came to Amy Coney Barrett, she was a priority. He promised long ago, I won't put a Supreme Court justice on the court unless they'll join me in eliminating the Affordable Care Act. So we knew that as a starter. And then he added as a grace note, and I want to make sure this justice is on the court, so if there's any election contests, I'll have 9 justices there. Not subtle, is it? That's why I said in the hearing, and since, there's an orange cloud over this nomination, an orange cloud that emanates from the White House. And that's why we come here today, just hours before the final vote, understanding what's at stake if the president has his way, if the Republicans have their way, if Amy Coney Barrett is on the bench by November the 10th, then she's in a position to strike down a law which provides health insurance for 23 million Americans. There's the linkage I mentioned earlier. In the midst of a pandemic, with 8 million Americans having been infected, in the midst of a pandemic with over 222,000 American lives lost, in the midst of a pandemic setting new records as this COVID-19 virus invades our towns and cities and counties and states again. In the midst of this, the Republican leader, Mitch McConnell, says we have no time to discuss COVID-19. No, but we have all the time we need to make sure we have our Supreme Court justice on the bench when the future of the Affordable Care Act is decided. There's been a lot of questions as to whether Amy Coney Barrett is qualified. She's impressive in her answers to questions. I am sure that she has a head full of law. You can tell it when she answers, which is rare. You can tell why she was a law school professor and now a circuit judge. But the purpose of our hearing was not just to figure out if she was smart, properly educated, licensed to practice law, all of that aside. The purpose of the hearing, from my point of view, was to try to determine not what was in her head, but what's in her heart when it comes down to basic questions. Because you see, at the bottom of this is the Affordable Care Act and its fate, and the fact that she has published on more than one occasion her opinion of that law, and not surprisingly, it's negative. I want to tell you a moment, I want to get personal for a moment about this Affordable Care Act before I talk about Amy Coney Barrett and her philosophy. I want to introduce you to a young man from the state of Illinois. His name is Alex Eccles. He's from Chicago. I met with him recently. Big smile, right? Well, when he was 9 years old, 2 of his mother's best friends were diagnosed with breast cancer and passed away before they reached the age of 50. As Alex moved into high school, his mother was diagnosed with breast cancer. Thankfully, she got treatment, and today, 20 years later, still in remission. Later in high school, Alex lost his young cousin to leukemia. Shortly after that, his aunt passed away from lung cancer. Alex emphasized that all of these black relatives and friends had their cancer discovered at a late stage, demonstrating a discrepancy in early screening for communities of color. The Affordable Care Act helped to address this disparity by ensuring free preventive screenings, including in private insurance. Hear that. 10 years ago, when we passed this law, we ensured that people could get private screenings, early private screenings for the detection of a cancer in its earliest stage when it could still be treated. As fate would have it, when Alex turned 29, he was diagnosed with non-Hodgkin's lymphoma. He was uninsured at the time, but thanks to the Affordable Care Act, he was able to get enrolled and access the care he needed. He received treatment at several hospitals in Chicago and ultimately chemotherapy and a life-saving bone marrow transplant at the University of Chicago Hospital. Today, he's in complete remission. How about that? He lives in Chicago with his wife, is active in leadership training programs and advocacy. He wrote me a note. He said, "Senator, if it were not for the Affordable Care Act and being able to gain access to health care at that time, then I'm not sure I'd be alive right now to share my story." Why do I tell you that story? Because the future of his health care depends on filling this nomination to the Supreme Court, and whether the person who fills it is going to eliminate this law and protection or protect it. Here's another fellow I met. His name's Alex Marcellonis. I remember meeting Alex because, like me, he has Lithuanian heritage. We talked about it. I met him during an immigration event. Due to complications of a knee condition, Paul Marcellonis was no longer able to work at the Sears store. He lost his employer-based insurance when he was in his early 60s. Paul's wife used to worry about relatives who had cancer, and she said to him, "I hope that doesn't happen to me because we can't get insurance and we have nowhere to go." Then Paul received a prostate cancer diagnosis when he was 63, unfortunately 2 years too young for Medicare. Thanks to the Affordable Care Act, he got enrolled in the Cook County County Care Medicaid expansion coverage. I'm happy to say that because I joined with Tony Preckwinkle, the president of the Cook County Board, to ask then President Obama to give us a waiver so we could extend Medicare coverage early on under the Affordable Care Act. He gave us the waiver, and we covered 120,000 people with Medicaid protection, and one of them was Paul. He was able to access the care he needed, including 45 radiation treatments. Insurance cost $175,000. Today, Paul's cancer-free. He still depends on the Affordable Care Act for preventive screenings under Medicare. Currently takes 7 medications, blood thinners, allergies, blood pressure, metformin. If the ACA were to be eliminated, he'd be charged more for these prescription drugs. That's another thing we did, in the Affordable Care Act. We reduced the cost of prescription drugs for people under Medicare. When it's eliminated, that reduction disappears. If Republicans succeed in terminating the Affordable Care Act at the Supreme Court, Americans like Paul will pay the price. So you wonder why we're coming to the floor with these speeches late on a Sunday afternoon? Because these people asked us to. They asked us to come up, stand up for them, and say what they can't say on the floor of the Senate. That's why we're here in the midst of a pandemic. That's why we're here with a nation that values health care as much as anything else that we have as American citizens. And that's why when we ask Amy Coney Barrett some basic questions, we expected to at least get some indication of an answer. She wouldn't answer basic questions. Senator Leahy was there. He was following it. What we saw was a practiced avoidance of even telling us the basics. She styles herself as an originalist, and I'll talk about that in a moment. An originalist supposedly values the Constitution, in fact, depends on it, finds guidance in it that other people can't see in the words they find in the words, really delves into the Constitution, honors it, swears by it. And yet when we ask about basic constitutional principles, basics, written in the words of the document itself, time and again she'd say, "I really wish I could answer, but a case may come before the Supreme Court someday on that, and I'm just going to have to duck that question." She wouldn't tell us whether the President of the United States could unilaterally delay the presidential election. How about that? Only 3 separate references in the Constitution to that deadline and date for a presidential election, And she couldn't answer that question. Can the president unilaterally delay an election? She couldn't tell us whether there should be a peaceful transfer of power from one president to the next. Please, Professor, Judge, you know in your heart of hearts that without a peaceful transfer of power, you don't have a democracy. When it came to the issue of voter intimidation, and why did we raise that? Because there's a call to arms among some of the militia groups and others in this country to harass voters. She wouldn't tell us whether she thought voter intimidation was unlawful. She wouldn't even answer a question I asked her in writing as to whether President Trump was legally accurate in saying, quote, I have an Article 2 where I have the right to do whatever I want as president. Whatever I want as president. 3 separate branches, balance of power. Thought that was in that Constitution the originalists venerate. Not enough for Amy Coney Barrett to answer the question. She just said it wouldn't be appropriate. You know, a case may come before us someday. You never know. Now that's troubling. It's not a question of protecting her prerogative as a future justice. It's a question of dodging the question over and over and over again. At one point, Senator Kennedy, who will be speaking here shortly, asked her about climate change. She said, really don't have a view on that. No, haven't really thought about climate change. 48 years old, a lawyer, a law school professor, a circuit judge, the mother of 7, never crossed her mind about climate change as to even whether it exists. Judge Barrett refused to comment on the landmark Supreme Court decision of Griswold versus Connecticut. That's the case in which the Supreme Court confirmed that there is a right to marital privacy and that criminalizing contraception violated that right. It was a fundamental decision that led to loving in terms of people marrying, interracial marriage, and ultimately to Roe versus Wade. She wouldn't even opine as to whether or not that was properly decided. She wouldn't commit herself to recuse herself from election disputes involving President Trump, even though his comments at a minimum have created an appearance of partiality that warrants recusal under the judicial recusal statute. I asked her in the 30 minutes initially that we were given to explain a 37-page dissent in Cantor versus Barr. Now, this was a case where a fellow named Ricky Cantor ended up defrauding the federal government of millions of dollars. He was convicted of mail fraud. He ended up advertising that the cushions he had for shoes had been approved by Medicare. They had not. And then started selling them in volume across the United States, and he was caught at it red-handed. He ended up with a massive multi-million-dollar civil settlement with a substantial fine and penalty and 1 year in federal prison. And he came out after his year in federal prison and said, I'll tell you what's unfair. After all I've been through, I can't buy an AK-47. What's wrong with my Second Amendment rights? That was the case. His, Ricky Cantor's, Second Amendment rights to buy a gun. So he brought this case before a 3-judge panel in the Seventh Circuit where Amy Coney Barrett was presiding with 2 other judges and said, I want to assert my Second Amendment rights. It's just not fair, after what I've been convicted of, to say I should be denied the right to buy a gun. Amy Coney Barrett spent 37 pages explaining why he was right. The other 2 judges on the case went the other way in a hurry. Both Republicans, I might add, Republican appointees. But she stuck to her guns, so to speak, and said that as far as Ricky Cantor was concerned, it was just fundamentally unfair. You see, because he was just convicted of a felony, not a violent felony, really. Then she went a step further in the issue of voting rights. And she really got down to the basic question. Could you be denied a gun, to buy a gun, if you, quote, just committed a felony, close quote? Or could you be denied the right to vote if you just committed a felony? Not a violent felony in either case. Well, she reached a conclusion that the right to bear arms and the right to vote were 2 different kinds of rights. That the right to bear arms was individual, so Ricky Cantor even if he'd committed a felony, could not be denied a gun. But she went on to say that when it came to the right to vote, that was a, quote, community right. And that as a consequence of it, that if you committed a felony, not even a violent felony, you could lose your right to vote. What an amazing conclusion. That is the originalist mind at work. I had to remind her she lives in the state of Indiana. Guns flow across the border from Indiana into Illinois and the city of Chicago. We have a domestic violence problem in that city that is serious and deadly every single darn weekend. And many of those guns, they traced them incidentally, the federal agencies did. 20% of those guns come from her state of Indiana. And many of them come from gun shows where there are no background checks. So you know what happens. The gangbangers and thugs drive over to Indiana to a gun show, fill up the trunk of the car with guns, and head for the streets of Chicago. I said to her, she had to know this, growing up or living in South Bend, Indiana, with her kids growing up there. And if she knew that, how could she be on the side of making it easier for anybody to buy a gun who's been convicted of a felony? But she did. Her originalism was at work. Mr. President, I would like to ask, well, before I do, let me say this. I want to say a word about originalism. Originalism is not just some foreign language you pick up on Babbel. It's a mindset. It's a mission statement. It's the belief that original text in our Constitution reveals all the answers to today's challenge. Now, all of us here have taken an oath to support and defend the Constitution, and I don't take an oath lightly, and I'm sure none of my colleagues do either. But the question is about that document itself. Does it have in its entirety what we need to know about our rights today in dealing with the constitutional issues that come before us? Let me mention to you what the mayor of Chicago said a week ago when she was asked about originalism. Lori Lightfoot. She said, since the Constitution didn't consider me a person in any way, shape, or form, because I'm a woman, because I'm black, because I'm gay, I am not an originalist, Lightfoot said. I believe in the Constitution. I believe that it's a document that founders intended to evolve. And what they did was set the framework of how our country was going to be different than any other, and whatever there was in the original language, that's it. Well, that language excluded 50% of the people living in this country today. So let's be very honest about that Constitution. Women could not vote in that original Constitution. African Americans were not even counted as whole people. They were 3/5 of a citizen. And the list goes on. I still venerate it for creating the democracy that we enjoy today. But I don't believe that the Founding Fathers could possibly intuit where we are in America at this moment. What is at stake with originalism is this battle with judicial activism. What is behind this battle with judicial activism goes back to that moment after World War II, when Chief Justice Earl Warren, a Republican appointed by Eisenhower, and Chief Justice Warren Burger, a Republican appointed by Nixon, set out to make all Americans equal under the law. 1950s, they tried to end segregation through Brown versus Board of Education, prohibiting racial segregation in public schools. 65, they protected the right of married couples to use contraception, the Griswold case. 67, they legalized interracial marriage, Loving. 73, Roe versus Wade, they tried to give women control over their own reproduction by legalizing abortion. The justices based their decision on the Due Process Clause of the 14th Amendment passed by Congress in 1866, ratified in 1868 in the wake of the Civil War. Congress developed this amendment after the legislatures in former Confederate states passed black codes severely limiting the rights and protections for the formerly enslaved. Congress intended for the 14th Amendment to enable the federal government to guarantee that African Americans had the same rights as white Americans, even in states where legislatures wanted to keep them in some form of quasi-slavery. Justices in the Warren and Burger courts used that amendment to protect civil rights a century later. They argued the 14th Amendment required the Bill of Rights apply to state governments as well as the federal government. This is known as the incorporation doctrine, but the name matters less than the concept. States cannot abridge the individual rights any more than the federal government. This doctrine dramatically expanded civil rights. But from the beginning, there was a backlash against New Deal government principles, and as early as 1937, there were those demanding to end the active government, and return to the world of the 1920s, where businessmen could do as they wished, families and church managed social welfare, and private interests profit from infrastructure projects. They didn't gain a lot of traction. The Americans didn't care for that interpretation. But the expansion of civil rights under Warren and Berger was a whole new kettle of fish. And I want to say that what I'm sharing with you here is an amazing summary of Heather Cox Richardson, who on a regular basis writes a letter to Americans. Opponents of the new decisions insisted the court was engaging in, hold on tight, judicial activism in trying to strike down discrimination and bigotry, taking away from voters the right to make the decisions about how society should work. They said justices were, quote, legislating from the bench. Heard that before? They insisted the Constitution is limited by the views of its framers, that the government can do nothing not explicitly written in the 1787 document. Faced with confusion over the exact meaning of the Constitution, some revised their position in a few ways, one of which was to rest on textualism or originalism, the idea that a law says exactly what it says and nothing else. This is the foundation for today's originalists like Amy Coney Barrett. So when you hear this debate about, I'm just following the Constitution, I'm just following the text, I want to go to the original document. I don't want to see judges who are activists. It had its origin in the 1950s when two justices on the Supreme Court appointed by Republicans stepped up and said, it's time for us to be serious about civil rights in America. Some politicians and those who support them have never gotten over it. We're still debating it today. So let me conclude. I see my colleagues waiting patiently, and I'm sorry it took a long time, but this is as serious as it gets as far as I'm concerned. Let me conclude by saying this. There's so many issues of critical importance at risk in what we're about to do. A 6-3 conservative majority on the Supreme Court will challenge not only the future of the Affordable Care Act, but voting rights and the outcome of an election, the right of privacy and choice, civil rights, environmental protections, marriage equality, worker protections, the fate of dreamers, gun safety laws, and so much more. We asked Amy Coney Barrett repeatedly, many of us did, because the president has said he put you on the court with a mission, and you're denying that it took place, will you at least promise us that you'll recuse yourself from cases directly relating to these issues? And she said she might not. There was a process she might follow. There's something else she could do, Mr. President. You see, if this Senate goes forward and approves the nomination of Amy Coney Barrett, she has one last decision before she becomes a Supreme Court justice. She gets to choose the day when she's sworn in. I would like to suggest to her, for the integrity of the court and to remove any possible cloud over her nomination created by the president's tweets and promises, I would like to ask her to pledge to the American people that whatever the Senate does, she will not take the oath of office until a new president is sworn in. If it's a re-election of President Trump, so be it. If it's Joe Biden, so be it. But if she will wait and absent herself from any election contest or debate on the Affordable Care Act, it will start to remove this cloud of doubt, this orange cloud of doubt, which is over her nomination. I'm going to stand up for the constituents I talked about today and so many others whose future hangs in the balance, and I'll vote no on Judge Amy Coney Barrett. I yield the floor.
The senator from Colorado.
Thank you, Mr. President. I ask unanimous consent that I be allowed to complete my remarks on the wildfires in Colorado.
Without objection.
Mr. President, I look forward to coming to the floor and speaking about the nomination that's currently before the United States Senate and the nomination of Judge Barrett to be placed on the United States Supreme Court. But at this point, I think it's important that we talk about what's happening in Colorado as we speak, because of the heroic men and women who continue to fight our nation's fires and certainly the devastating and catastrophic fires that we're seeing right now in Colorado. This year, we've already seen two of the largest fires in Colorado history, burning over 200,000 acres. Wildfires that started out at 20,000 acres, 25,000 acres, and then within hours grew 80, 90, 100,000 acres in a day. Unheard of growth for wildfires. The picture that I am showing you here is Estes Park, Colorado. Most people may be familiar with Estes Park. It's the gateway to Rocky Mountain National Park. You can see Lake Estes here and the town here. The town has been evacuated. A town of thousands of people has been evacuated because of two fires that are now threatening the area. One fire is the Cameron Peak Fire, which became the largest fire in the state history, only to be challenged by another fire coming through Rocky Mountain National Park called the East Troublesome Fire. Both are impacting Rocky Mountain National Park, the city of Estes Park, the city of Grand Lake, city of Granby. Overnight, they did receive a winter storm. It's snowing now, and it is reducing the fire activity. It will not put the fire out, but my prayers, thoughts continue with the men and women who are fighting this fire so valiantly and the people in these communities who are in harm's way. We know that homes have been lost. We don't know how many, but we know that homes have been lost, and we certainly acknowledge the loss of life that has already occurred. A couple in Grand Lake who stayed in their home when the fire came through. They were together, but we pray for them and their families, and we mourn their loss. The East Troublesome Fire is in the Medicine Bow Route National Forest and Thunder Basin National Grassland. It's got a team, Type 1 management team already assigned. It's the number one priority of the U.S. Forest Service in the country right now because of the aggressive fire behavior with spotting that has threatened places like Estes Park. Evacuations, road closures, trail closures, has over 500 people right now assigned to this fire. The Cameron Peak Fire has about 1,100 personnel working on the fire right now. We know about 470 structures have been lost. It's over 208,000 acres. The Calwood Fire in Boulder County has a Type 2 management team fighting the fire right now. There are evacuations in effect, nearly 400 people fighting this fire, 28 structures lost. The Ice Fire, an ironic name, in the San Juan National Forest near Silverton, Colorado. We know that it's about 600 acres right now. The Williams Fork Fire, which has been burning for months in Colorado and Grand County, Arapahoe and Roosevelt National Forest. We know that there have been several communities and energy infrastructure threatened by all of these fires. And if you think about this entire town being evacuated, the Colorado Big Thompson Project, which provides a great deal of water to the Front Range of Colorado and through the South Platte River Valley, diversions were stopped, energy production impacted, major utility transmission lines have been lost, and of course the loss to some of the most magnificent areas of Rocky Mountain National Park, perhaps an untold story that we will learn about in the coming days. This Congress and the past Congress has not been idle in the work that we have done to protect our resources. In fact, this last Congress, we put an end to a practice that was known as fire borrowing, which involved raiding accounts that were not meant to go to suppression of wildfires to pay for increasingly expensive firefighting seasons. The fix for fire borrowing was included in the 2018 omnibus spending package. What that means is we will no longer be cannibalizing funding for fuel reduction for mitigation that could have prevented a fire like this. Instead, we will be fully funding the firefighting effort and allowing those mitigation dollars, those fuel reduction dollars, to continue to be used so that we can prevent this kind of fire from occurring. We've also passed legislation for water resilience projects, categorical exclusions to help with forest management. We've passed Healthy Forest Restoration Act language that includes fire and fuel breaks. We've worked on 20-year stewardship contracts with cottonwood reform. We've proceeded with reforms to fire hazard mapping initiatives and to fuels management for protection of electric transmission lines and good neighbor authority to help make sure that we can continue to give tools to our land managers. The 2018 Farm Bill built with many of the reforms that we passed in 2014 Farm Bill changes. We've worked to expand the Collaborative Forest Landscape Restoration Program, doubled its funding, and to help expand good neighbor authorities to tribes and to counties. All of these tools will help us deal with the wildfires, but certainly they're not going to put this fire out today. So I come to the floor just to thank the men and women who are fighting these fires, to the leaders in these communities, the county commissioners, the sheriffs, the law enforcement personnel, first responders who've done a magnificent job in protecting structures, protecting their communities, protecting their people. I commend you, and know that you have the support of everybody here in our efforts to give you the tools you need to do your jobs, to be safe, and to protect our greatest resources and communities. And so, Mr. President, again, I look forward to coming to the floor to speak about Judge Barrett